have our invocation.
Dear God, I'd like to pray for our community, for our first responders, our fire, police, and military. Be with us today. Help us to bind our differences and proceed forward in the best way for the community. Thank you for all the many blessings you've given to this community and the beautiful place it is today. Be with us in the future. Amen.
Call to order, new business. I think there's no new business.
There are the three matters noted on the agenda, and with your permission, I'll jump ahead to the first one.
Yes, sir. Thank you, Council.
All right. Mr. Chair, with your permission, I'm going to speak from up here, and I'm going to pass out a short resolution that I've adopted that will achieve the purpose that we set out to today. I might not have enough copies. It might be that I need to ask you all to share. Forgive that. Gentlemen, I'll read the resolution so that you can hear it in a moment here. All right. We are here today to acknowledge recent events and the mandate that was handed to us by Danville-Boyle County, and to get back to work in a crucial juncture in the life of this body. I have seen the investment and commitment of this commission and the thorough professionalism and expertise that was brought to the recruitment committee, in the clear passion evident in discussion during this moratorium, and over the last several years in a continuing improvement among our ranks. It's characterized by civic interest and strong engagement with commission business. That said, I would like to offer a brief synopsis and then a resolution for your adoption. Danville City Commission and Boyle Fiscal Court met a joint session Friday afternoon, September 2nd. Junction City and Perryville were not represented at this workshop. The legislators present instituted a moratorium on Planning Commission activity. The moratorium resolution's stated reasoning can be summed up as concern over financial disclosures and a review of best practices. The jointly met governments appointed a task force of county and city heads and their teams. On September 7th, a letter was handed down to this commission with the task force's requests. You've seen this letter. It was circulated among commission, board, and staff. You voiced your concerns about this letter. I've heard that a lawyer advising Junction City cast doubt on the reach of the moratorium, and I know that many of you have felt blindsided by the moratorium and the stated grounds for its imposition. I wrote in response to the task force seeking clarification, and I'll share with you some of the task force's guidance. Specifically regarding number 5 of the 6 acknowledgments which the task force requested, we read number 5 as an admission that no member of planning and zoning complied with disclosure requirements. I raised this issue to the task force that at the very least, the Boyle County appointees had all turned in their disclosure forms. The response I received was that the touchstone going forward shall be disclosure at the time of appointment. Then regarding acknowledgement number 6, we read this as an admission that we created a conflict of interest by appointing the chair as interim head of the body tasked with overseeing him. I wrote to the task force that the chair and commission oversee planning staff, seeking to clarify this dynamic, especially since that dynamic was cited as creating a conflict of interest. I was told that the task force prefers that any interim director not be picked from among current commissioners. This has been the course of events and the discussion around them. I'd now like to read to you a proposed resolution responding to the task force. Whereas the Danville-Boyle Planning Commission, with membership from Perryville and Junction City, met this 14th day of September 2022 in acknowledgement of the moratorium placed upon its actions. And whereas the Planning Commission acknowledges the stated concerns of its parent governments in instituting the moratorium, And whereas the Planning Commission desires to lift the moratorium and return to planning and zoning work. And whereas the Planning Commission gives assurance to its parent governments of a commitment to the obligations placed upon it by state law and also by those same parent governments. And whereas the Planning Commissioners know that a return to planning and zoning work will be the surest vindication of the interests of good government. Now therefore it is hereby ordered and adopted, the Danville-Boyle Planning Commission does hereby adopt and acknowledge the 6 enumerated acknowledgements set forth in the September 7th letter sent by the City County Task Force, as contextualized herein. And the Planning Commission does adopt and incorporate that letter by reference, adopted this day. Mr. Chair, I'd ask for a motion adopting that resolution, and I would ask that my remarks, which I have printed, be admitted as an exhibit into the record today. And this would be an appropriate time for a motion on that resolution, then any discussion following thereforth.
I'd like to make that motion if there's a concern.
Commissioner Collier has made a motion. We have a second.
I'll second it.
Commissioner Davenport is second. We have a motion and a second. Discussion on the motion.
I think, Henry, several of us had concern about item number 5. That it appears to be that we're acknowledging as written by them.
Right. And that's, one of the 2 things that I raised to you is what they responded on. And, the response that I got from the task force and the representative is, okay, we discussed at our Friday, September 2nd meeting that county appointees had submitted their documents, but we were asking for disclosure at the time of appointment. I can't say, I don't have that in writing. I was speaking with one member of the task force, and I can't say whether that's their official response or just an off-the-cuff response that was provided to me, but that's what I was informed, that they're asking for disclosure at the time of appointment. And as for the scope of our admission, it was my hope that we could add some context to that admission by tendering my remarks in the record today, which include the fact that the Boyle County Commissioners had complied. Does that address your concern?
Well, I would like some clarification on their statement of compliance on disclosure upon appointment.
Right.
So if the city appoints the commissioner, would it not be incumbent upon the city to make that disclosure requirement clear at that time, or to even present that to them at that time? Which I can honestly say no one has ever received that or been given that or been acknowledged, that acknowledgement being given to them.
Yes, Mr. Chairman, it does sound like that would be incumbent upon them, but now that this has been raised in the context that it has, I feel confident that it won't even fall to the city anymore because we've been made blindingly aware of this issue. So, yes, I would say it is probably incumbent upon the city, although we are an independent body, and so now that's a responsibility which we won't miss again.
I think it's important for us to put the words moving forward from this point and make sure that that is emphasized and to acknowledge that the county appointed commissioners were sent a disclosure request, which they all filled out, and the city appointed commissioners were not, and that we will do so moving forward from this time.
Can I add a supplement on here? Because I took a little time and looked up some of the ethics and paperwork that we have on here. the magistrates had a vote and a second reading of the revision to those ethics back in July 26th. That topic was in there. It was also on the first reading on April 12th. The line that talks about that, those people that are appointed, and eventually you read the 26-page document, it talks about financial statement being required on there. So I guess I was thinking along the line that even though we did not know it and we were not aware of it, the fact that that document was accepted on there means that technically we are in violation of not fulfilling that requirement for this year. I mean, that's the interesting twist on here. You get into the dates and times in certain documents. And I know as well as you guys do that some of the documents are so elaborately the way it's released, and they tag you along the way that you never knew it, and it suddenly becomes one of those topics. We should just accept it and move on. And I think what Mr. Smith here has in his last line there isn't ideal, but it is not a bad situation. It is what it is. It's the knowing fact that we have. I do like the way Judge Hunt had referred to it in one of his documents, that looking at such groups like planning and zoning periodically and making sure that things are being adhered to is the right thing, because things do drift off, not by intent, but by accident in that category. And I think it's one of those categories. We didn't know it.
Well, in all due respect, I know on the city side, we asked for clarification, and we were told we didn't meet that requirement. And then, in a matter of months, that changed. So I take offense when they blank, when we make an effort, and then all of a sudden, we're the ones who we're not doing their due diligence.
I can see your perspective. You're absolutely correct if that's what you received.
And
in
I
that category.
take umbrance in signing something to that effect.
I myself was not aware of this until the judge sent out the letter to the county people. That was roughly on the beginning of August, that it was needed and requirement. I was not aware of it at all. And I'm a new part in this group in January this year, so I have no previous involvement of requirements.
Well, I think,
listed.
I don't think anybody on this commission has an issue with signing a disclosure statement. I think if someone had brought that to their attention or had been kind enough to walk one down the hallway, this matter would have been resolved weeks ago, months ago, or never come up. So,
It is interesting your statement comes into the fact, the one thing I thought of that we didn't have, not having a director as a point of contact for those groups became very complicated in this information flow that was going on. Because suddenly we have groups reaching out from different ways of coming in. At least it appeared that way. I mean, they called Mr. Smith. They sent the note to him. They didn't send it to the commissioner, you or the vice commissioner, the information directly. It went to you on the arrangement on here. It probably would have directed through the director position and routed down to us, flowed down through us at a point of information. And that would have made it easier to flow in this arrangement. But we have different people coming out and reaching out, which is kind of also causing an issue of communication. That's the way I look at that perspective on here. And we both agree, as you just said there, the ideal here is to yes, and we'll go on to do what we need to do. We'll provide the financials and we'll go on in consideration on there. But, the original item number 5 was, yes, technically we're in violation of that because that the last revision of it was, of the second reading was July timeframe for the county arrangement on there. I did not look in the history to see when the city read it.
well, and again, in all due respect, when the county appoints someone or the city appoints someone, I think it's incumbent upon them at that point in time, say, you're my appointee, you're not a member of planning and zoning yet, you're my appointee, we require you to do this as our appointee.
Yes, and it did not happen in my case.
No, sir, it has not happened, period, to anyone.
Do I understand correctly that we asked for clarification on this very specific issue previously?
Yes.
Okay, so if that's the case, I think it's pretty simple to attach to this resolution that, because that's in the record. If we asked for clarification and they told us that we did not have to do it, then we attach that in the record as an attachment to this resolution. Does that make sense?
Commissioner Ruby, the one thing that's lacking from this is any kind of written record of that. But it's a conversation that I was made aware of, but I don't have any correspondence showing it to attach in the record.
Has the city asked any of its appointees to complete a disclosure statement?
No,
No,
No.
Okay? And I think that if you were to ask the county administrator, in a conversation that I had with her, she told me that she offered the disclosure form that the county sent to the county appointees to the city, and the city declined it.
So my comment is that I took umbrage also in the statement as if I failed or refused to fill out the financial disclosure. I don't like that. I appreciate your comment that the ignorance of law doesn't mean that you have the opportunity to not follow it. But I did take umbrage at it, and I feel that we need to clarify that it wasn't on any of the city appointees' part a desire not to comply. It was not being aware of the need to comply with financial disclosure. I think that needs to be included in the comments back.
For which you have still not been asked to comply.
Commissioner Ruby, I guess the response to that is that the letter of request that we received from the task force asked that we provide disclosure forms for all commissioners and the board and staff.
And we have complied.
Did they request that the commission, planning and zoning commission, come up with its own disclosure form? Did they ask that the planning and zoning commission request a disclosure form from the city, or their appointing governments? It just says that you have to fill out a disclosure form.
Right, and what I heard yesterday, and we might get a more official word on this, is that the Boyle County form is acceptable for all to use. Okay. The word from the county manager is that Boyle County will send its disclosure forms to us as we adopt its ethics ordinance. So I understand that to mean that Boyle County appointees will be sent it by Boyle County. And the city too.
The
Okay.
entire commission, if you're following our ethics ordinance, you will get your requirements from us.
Okay.
So does that mean you have to fill out two of them, or one will suffice?
One will suffice for my conversation yesterday.
I tend to agree with Sally, that is, I would like to see something in our response that acknowledges the fact that we didn't knowingly fail to provide these disclosures. We just had no knowledge of it. It really, I just cannot believe that you would suspend planning and zoning activities for that, you know. I know, I'm sure that wasn't the only reason, but like you said, just walking down the hall and said, you forgot to fill these out, or we have no record, could you fill these out, would have resolved it all.
This is tied into the ethics in the state, and we're all with strong integrity. We do the right things. We believe we do the arrangements. It's perceptions that get us in trouble at times. And we have not, I don't think any of us here in this county have ever had an issue on it, but clearly, if you have stories in the state of Kentucky where ethics is not being followed. And so financial things is a key factor on there.
I don't think anyone has an issue with the ethics requirement. It's how it's stated is where the issue is. And I think there's plenty of blame to go around to everybody, but some people aren't willing to take the blame. They want to throw it all on one group. And virtue of the fact that it's coming from them, it's their disclosure, it needs to come from them when you become a member of the commission. So that's been a lack of responsibility on someone else's behalf.
Well, I started by making a motion, which is what Henry Smith had said, and it was stating the acknowledgement that all 6 enumerated acknowledgements set forth in the letter. And what we've got here is a variation on one of those. Is that the way I understand where we're at this point? Because it does not include what we're talking about at this point. I want to make sure. We still are around that particular motion, so I don't want to forget where we started from in the picture. And I'm still satisfied with those as it's presented in here. Now, I know I'm sitting next to Mr. Smith, so he has a comment or two on that category.
Based on the request that I'm hearing for additional language, it's the second to last whereas, where we talk about a commitment to obligations of law. We might add another whereas that the commission notes that they were not sent disclosure forms and they did not knowingly neglect compliance.
I'm comfortable with that.
Well, then you go a step further and made it aware.
Henry, you don't have a physical record of that conversation, but do you know the date of it and who you spoke with that you could at least reference?
I don't know the date, and I don't know the date because I was not the one who had the conversation. We're dealing with a couple layers of hearsay here.
Okay, so then we cannot reference that.
I would suggest that we not reference that.
I would prefer it not to be in there too, but I think what you had proposed there is a reasonable statement.
I do too. I would like us to move forward, if we can, to do what we were appointed to do, which is to do planning and zoning.
I agree with Commissioner Davenport in that wholeheartedly.
And for clarity again, would you read your proposal words there again, Mr. Smith?
The addition.
Yeah, the addition.
The addition states, whereas the commission notes that they were not made aware of disclosure forms and they did not knowingly neglect compliance.
So are you changing the motion?
Yes, and confirm that all new commissioners will be, moving forward, in compliance, whatever, you know what I'm saying, right?
Commissioner Ruby, the previous paragraph says the Planning Commission gives assurance to its parent governments of a commitment to the obligations placed upon it by state law and also by those same parent governments. I think that gets at the idea of new commissioner compliance.
Yep.
So where I was leading is exactly, you're referring to, Commissioner, is I'd like to modify the motion to add the inclusion of that particular sentence that you've got drafted there.
So if it's up to the commission to get the forms from new appointees, what happens if the mayor appoints somebody and they refuse to fill out a form? Do we have the authority to decline the person?
Well, it's my understanding now that the county will be supplying those forms, and I don't know what your procedure might be for obtaining a form filled out before confirming an appointment.
I would think.
Ms.
I would
Wagner?
think- I don't want to interject, but I would think if this is the way it's going to be, that when they appoint someone, they sign the form, and then they present them to planning and zoning as a member. Because they're in compliance with their rules.
Please. And, yeah.
Say your name and address, please.
My name is Julie Wagner. I live at 105 Venetian Way in Danville here. I'm the Boyle County Administrator. I'm not an expert on this, but I can only tell you the way I would envision this working is if there is first of all, these forms have to be filled out annually, and I don't think you understand that it is an annual requirement. If you look at the special purpose government entities, it is annually. So first of all, I would anticipate that I would send the form to the new appointee. Once the governments vote on you, you are on. However, if it's not sent back, the ethics committee is the one that manages these, not me. They keep them, they file them in the clerk's office. I never look at them. But the public does have the opportunity to look at them. They are public record. What the Ethics Committee has decided in the ordinance is if you are in violation, there would be financial penalties. I think it's $25 a day that would be imposed if you go through several layers of not responding.
Ms. Julie?
Yes, ma'am.
Could you please tell me why Junction City was not notified? We still haven't been notified.
I can't answer that.
I mean, we haven't been in there.
Yeah. I can't answer that.
Was
Yeah.
it, you had your own government over there.
Right.
And I know Terrible wasn't notified either.
Yeah. Yeah, I don't,
I mean, I do have one on file,
yeah,
but
yeah.
I just think it's kind of.
Yeah, I can't, I don't know the answer to that.
What's going on.
Yeah, I don't know. No, I don't.
So you're saying it's going to be up to the ethics committee to enforce this?
They do enforce the ethics ordinance, and this is required through the ethics ordinance and special purpose government entity. I would hope it would be part of your annual training, new board member training, to explain how the special purpose works and that you have to do this. I mean, that would be the easiest way,
Well,
is
you-
part of your board member training.
That would be one of those things you'd have to add to the list.
Right, I know.
I
It's,
think it goes without saying that if you're a new member and you're appointed, and
Right.
the appointed government requires you to sign a disclosure statement, then that has been established. And then if it comes next year, the following year, you've already done it, that point's been made.
The financial statement is referring to the finances you had in the previous year.
it's the previous year.
It only considers the previous year.
Yeah,
So prior to that point, it's not a blanket statement. You'll be responding to the questions on those 2.5 pages every year because they're referring to whatever you filed previous category year.
The point is, when you're appointed by a government, because you're appointed by that government before you become a member of the Plain Zoning, if they would say, we're going to appoint you, please sign this disclosure, you're going to get one every year. End of story.
I mean, I could take that
That's not
tomorrow
happening.
to the task force.
I agree,
but-
that has not happened. That is
Well,
correct.
let's state it. So we have a motion. We have a new motion.
I second his revised motion.
So we have a motion. We have a second. Any further discussion? We have. All in favor of the motion before us?
Aye.
Aye.
Tom?
Aye.
Okay, so it's a unanimous. All right, so at this point, we'd like to have a motion to go into executive session concerning personnel issues or matters. I have a motion.
So moved.
Got a motion
A second.
and a second. All in favor?
Aye.
Mr. Chair, I've been told we're back on the live stream now. We've come out of executive session held for the purpose of discussing personnel matters. The lone action that is to be taken from that executive session is the appointment of an interim director. That interim director, if someone is to make the motion that I'm about to state, is to appoint Gary Chester as the interim director of this planning commission, substituting him for previous interim directors, and authorizing him with the same scope of duties that those directors had as those duties were amended at the August meeting of this planning commission.
I think we past chairman of the planning commission.
I would amend the motion to note that this appointee, has been the past chairman of this commission.
But is not a current member.
Yes, Commissioner Davenport.
I will make that motion, as stated by Henry.
We have a motion on the floor,
I'll second it.
and Commissioner Boyd seconds. Any further discussion of the motion? See none. All in favor of the motion?
Aye.
Aye. It's unanimous. Thank you. No.
The one final matter of this is that there's a matter of personnel discussion that must be continued at this time, and so it would be appropriate for a member of the commission to move to table that matter to a continuation of this meeting to be held Tuesday morning, September 20th, in City Hall at 9 a.m.
Okay, we have a motion. Commissioner Boyd makes that motion. You have a second?
I'll second.
Commissioner Manning seconds that motion. Any discussion? All in favor?
Aye.
Aye. Unanimous. All right, thank you.
Do we need to move to adjourn this meeting until then, or is that it?
That's it. Lisa says adjourn. If we could have a motion to adjourn until our continuation on Tuesday, the 20th.
I move to adjourn.
All right, we have a motion from Commissioner Ruby to adjourn until further continuation. And Steve?
Yeah, I agree.
And Commissioner Griffin seconds that motion. All in favor? Motion passes. We are adjourned.